Brigham City, Utah v. Stuart, Supreme Court, 2006. Chief Justice Roberts delivered the opinion of the court. In this case, we consider whether police may enter a home without a warrant when they have an objectively reasonable basis for believing that an occupant is seriously injured or imminently threatened with such injury. We conclude that they may. 1. This case arises out of a melee that occurred in a Brigham City, Utah home in the early morning hours of July 23, 2000. At about 3 a.m., 4 police officers responded to a call regarding a loud party at a residence. Upon arriving at the house, they heard shouting from inside and proceeded down the driveway to investigate. There, they observed 2 juveniles drinking beer in the backyard. They entered the backyard and saw, through a screen door and windows, an altercation taking place in the kitchen of the home. According to the testimony of one of the officers, 4 adults were attempting, with some difficulty, to restrain a juvenile. The juvenile eventually broke free, swung a fist, and struck one of the adults in the face. The officer testified that he observed the victim of the blow spitting blood into a nearby sink. The other adults continued to try to restrain the juvenile, pressing him up against a refrigerator with such force that the refrigerator began moving across the floor. At this point, an officer opened the screen door and announced the officer's presence. Amid the tumult, nobody noticed. The officer entered the kitchen and again cried out, and as the occupants slowly became aware that the police were on the scene, the altercation ceased. The officers subsequently arrested respondents and charged them with contributing to the delinquency of a minor, disorderly conduct, and intoxication. In the trial court, respondents filed a motion to suppress all evidence obtained after the officers entered the home, arguing that a warrantless entry violated the Fourth Amendment. The court granted the motion, and the Utah Court of Appeals affirmed. 2. It is a basic principle of Fourth Amendment law that searches and seizures inside a home without a warrant are presumptively unreasonable. Nevertheless, because the ultimate touchstone of the Fourth Amendment is reasonableness, the warrant requirement is subject to certain exceptions. One exigency obviating the requirement of a warrant is the need to assist persons who are seriously injured or threatened with such injury. The need to protect or preserve life or avoid serious injury is justification for what would be otherwise illegal absent exigency or emergency. Accordingly, law enforcement officers may enter a home without a warrant to render emergency assistance to an injured occupant or to protect an occupant from imminent injury. Respondents do not take issue with these principles, but instead advanced 2 reasons why the officers' entry here was unreasonable. First, they argue that the officers were more interested in making arrests than quelling violence. They urge us to consider, in assessing the reasonableness of the entry, whether the officers were indeed motivated primarily by a desire to save lives and property. Our cases have repeatedly rejected this approach. An action is reasonable under the Fourth Amendment regardless of the individual officer's state of mind, as long as the circumstances viewed objectively justify the action. The officer's subjective motivation is irrelevant. We think the officer's entry here was plainly reasonable under the circumstances. The officers were responding at 3 o'clock in the morning to complaints about a loud party. As they approached the house, they could hear from within an altercation occurring, some kind of fight. It was loud and it was tumultuous. The officers heard thumping and crashing and people yelling, "Stop, stop," and "Get off me." As the trial court found, it was obvious that knocking on the front door would have been futile. The noise seemed to be coming from the back of the house. After looking in the front window and seeing nothing, the officers proceeded around back to investigate further. They found 2 juveniles drinking beer in the backyard. From there, they could see that a fracas was taking place inside the kitchen. A juvenile, fist clenched, was being held back by several adults. As the officers watch, he breaks free and strikes one of the adults in the face, sending the adult to the sink spitting blood. In these circumstances, the officers had an objectively reasonable basis for believing both that the injured adult might need help and that the violence in the kitchen was just beginning. Nothing in the Fourth Amendment required them to wait until another blow rendered someone unconscious or semi-conscious before entering. The role of a peace officer includes preventing violence and restoring order, not simply rendering first aid to casualties. An officer is not like a boxing or hockey referee, poised to stop a bout only if it becomes too one-sided. The manner of the officer's entry was also reasonable. After witnessing the punch, one of the officers opened the screen door and yelled in "Police." When nobody heard him, he stepped into the kitchen and announced himself again. Only then did the tumult subside. The officer's announcement of his presence was at least equivalent to a knock on the screen door. Indeed, it was probably the only option that even had a chance of rising above the din. Under these circumstances, there was no violation of the Fourth Amendment's knock-and-announce rule. Furthermore, once the announcement was made, the officers were free to enter. It would serve no purpose to require them to stand dumbly at the door awaiting a response while those within brawled on, oblivious to their presence.